All right, let's get started. This is 25CV001055. It is, I think the posture we are now, it would be Ms. Simmons versus Grady Multifamily. I know it's Ms. Simmons who has appealed from rulings below in the magistrate court. So Ms. Shackelford, you're here for Ms. Simmons?
Yes.
Great. And Mr. Douglas, you're here for Grady Multifamily. All right. And Ms. Shackelford, who do you have here with you?
Your Honor, my client Courtney Stewart.
Hi, Ms. Simmons.
Good morning.
Good morning. And who do you have with you, Mr. Douglas?
Brian Bowers, who is the assistant property manager at the apartment complex.
Okay. Great. All right. So let me just give you a sketch of what I understand is going on, and then I'll let you all take it from here. Ms. Simmons resides at, I'm sure the place is not called Grady Multifamily. If I were moving there, where would I be moving to?
Ashley Auburn Point.
Okay, that says that there as well. That's a lot of words. I'm gonna call it Ashley Auburn. So I'm moving to Ashley Auburn. Ms. Simmons lives there, and she, I believe, entered into some consent agreement with Grady Multifamily for Grady Multifamily to address a number of issues. I think this was under the auspices of, I think it was Judge Drake, was the magistrate judge, but regardless, a magistrate judge. And that was back in July of last year, so about a year ago, through this consent order. And we're back because Ms. Simmons contends that Grady Multifamily didn't do the things it committed to, or it was ordered to. You guys are going to give me the background, but either way, it was to do, and they didn't. And something about and on the eve of the hearing concerning Grady's alleged noncompliance with the consent order, Grady filed a dispossessory action. This would have been in January of this year. And then Judge Drake brought everything together, ruled in a certain way, and Ms. Simmons is challenging that ruling. I'm sure I'm leaving out some of the key pieces, but sort of at a high level, I think that's why we're here, Ms. Shackelford. And I know Ms. Simmons has also switched attorneys, but you've taken over the reins, and I trust are familiar with where things have been and where things are going.
Yes.
Okay. Before you dive into the substance of your arguments, are there procedural facts you want to share with me so that I'm better oriented as to what we're working through today?
No, Your Honor, the only new fact would be that Ms. Simmons no longer resides in that apartment complex, but other than that, no procedural facts to bring to your attention at this time.
Okay. And did Ms. Simmons move out of her own accord, or did this dispossessory go somewhere?
She moved out of her own accord.
Okay. And Ms. Simmons lived there alone with family?
2 children.
Two children. Okay. And they've all moved out?
Yes, Your Honor.
Are they in some other property owned by whatever Grady Multifamily is?
I don't believe so.
Okay, got it. And that doesn't moot things because, why? There damages owed, or there was rent abatements that need to be addressed?
Yes, Your Honor. We have claimed for not past due rent paid by Ms. Simmons. There was also supposed to be a rent decrease, which was not applied. There has also been a claim for punitive damages against Grady. So for the rent paid, moving expenses, punitive damages, those are claims that would not be moved by Ms. Simmons moving out of the complex.
Okay. All right, and explain to me what you understand happened at the last hearing in front of Judge Drake.
It was, Your Honor, do you want me to go to the podium, or am I okay right here?
As long as Mr. Douglas and I can hear you, that's everyone who needs to hear. So I'm fine either way.
It was my understanding that Ms. Simmons well, she was pro se. I don't think that your former counsel Claire was there, was she? For the last meeting, right? Okay, she was there. From the order and judgment that was entered, there was not a consideration about the repairs for the mold that needed to be done, the decrease in rent. There was not really much testimony, from Ms. Simmons about what procedural issues, or not procedural issues for her took place. There was a commentary that there was new ownership, and that for some reason that new ownership released Grady from their liability of making the mold repair. Which is a position that we do disagree with.
Meaning you disagree that there's new ownership, or?
No, that the new ownership excused Grady from making mold repairs or honoring the fact that Ms. Simmons' rent was supposed to be decreased.
Okay.
So she was still held to that higher rent than what she was supposed to be paying.
Okay. And was Ms. Simmons paying that rent into the registry or paying that rent to Grady Multifamily?
Well, she was paying to Grady directly, right? Yes.
Okay. So we don't have a pot of money somewhere that we're figuring out how much goes to Grady and how much goes back to Ms. Simmons. Okay. Anything else?
No, Your Honor, I believe that is it from our standpoint.
Okay. Mr. Douglas, just sort of procedurally tell me if you have any disagreements about where we're coming from with Judge Drake and what's properly in front of me.
I do. So I'm not really sure. I don't really have a clear understanding of the claim that the ownership was excused or the property was excused from anything. There is no new ownership.
Okay.
So what happened was there's new personnel. There was a property manager and an assistant property manager that was responsible for that typical role for an apartment complex for the greater part of Ms. Simmons's tenancy. In or around November or December of 2024, the ownership fired that property manager and that assistant property manager.
And were they direct employees of ownership, or was this a contract that we're bringing in the Jones property management firm?
Sure, good question. Integral Development owns Grady Multifamily.
Okay.
Along with about 30 other apartment complexes in and around Atlanta. And they have their own property management division. And so the same folks that manage the property are at least associated with the same group of people that own the property.
So when Integral fired the property manager, Integral was firing what I'm going to refer to as an Integral employee. They didn't say, we're ending our contract with this management company and bringing in it's all in-house.
It's all in-house.
Okay.
Just, you're not doing your job
Yeah.
well enough, you're fired,
Okay.
and immediately brought in someone else
Okay.
to take the place. Ms. Bowers is the assistant property manager that took the place of the assistant property manager that was fired.
But it was property manager and assistant property manager who were fired and then both replaced. Ms. Bowers as one of those replacements.
That's correct.
Okay.
And part of and what was established in that first hearing before Judge Drake was part of the reason they were fired for sort of not dotting their I's and crossing their T's in connection with issues like this, not addressing things timely. And so there was an admission, so to speak, that the issues that Ms. Simmons raised were not addressed adequately. What was established, though, notwithstanding that, was that there was no intention. It's not like they or Integral or the apartment complex, anyone associated with the apartment complex, had some sort of ill will or intention to not address Ms. Simmons's issues. And that was part of the reason why Judge Drake made the ruling the way that she did, was there was no evidence.
It wasn't willful that would trigger punitive damages.
That's right.
Okay.
And there was nothing willful about it. They just did not address it timely enough, and they were fired as a result. And the folks who came in did. That quite simply addresses the punitive damages portion.
Well, I don't want you to get into claims are good or bad. I just wanted to, you will get a chance to,
Right.
but I want Ms. Shackelford to go first. I just wanted to make sure we're in general agreement on what the procedural landscape is here in front of me, whatever it is that's being challenged from Judge. I just had trouble distilling what Judge Drake's final ruling was. So keep going if you have more on where we are procedurally.
Just briefly just say that I think the ruling recognizes an offset or recoupment theory that basically, even if there was some amount owed to Ms. Simmons, it was offset by the amount that Ms. Simmons owed in rent. And that's what I really wanted to address was, Your Honor asked a direct question about whether rent was being paid into the registry of the court or not. The reality is rent was not being paid. And so there still exists, I intend to present evidence in the form of my client's testimony and a ledger that demonstrates that there's still an arrears.
Okay.
Yeah.
All right, well, we'll work through that. Thank you. All right, so Ms. Shackelford, I am ready. This is a de novo proceeding, so whatever you want to share, if you're calling witnesses or tendering evidence, I'm ready.
Your Honor, since you've already heard a lot of opening, we'll be opening and I'll call Ms. Simmons.
Okay, Ms. Simmons, if you'll come on up here, please.
They start that says we say get to court street code, number of streets that we got. Why you gonna state your name and spell out the court record?
Courtney Simmons, COURTNEY, Simmons, SIMMONS.
All right, Ms. Simmons, we're here on an appeal, and you've heard that the judge understands a good portion of why we're here. But I want to go over again,
Sorry,
just.
Judge. I'm having a hard time hearing what she's saying.
Okay.
Okay, if you'll just bend that microphone towards you, there you go. That should
Can you
spread
hear
it
me?
around.
Can you hear me now?
We'll see.
Okay.
Keep trying. Oh, and if you could bend the microphone down towards you, it bends. You're not going to break it. Don't worry. It should bend at the bottom. There you go. Excellent.
Okay, so, it's my understanding that you were a resident at one of Grady's properties, correct?
Correct.
Can you tell me the name of that property?
Ashley at Auburn Point?
And were you residing alone?
No.
Who was residing with you?
My daughter Trinity Harrison and my son Preston Harrison.
How old is your daughter?
Well, currently my daughter is 16 and
And how old is your son?
he's 6 years old.
How long did you live at Ashley Auburn Point before how many years did you live there?
I believe I moved in 2014.
And your daughter is, 2014, so that's a long time ago. So your son wasn't even alive.
No.
Got it. Okay.
So during the time that you resided at Auburn Point, your daughter and son lived with you. Did you ever notice any health issues with your kids while you were living there?
I did,
What kind of health issues and with whom?
particularly with my son when he was younger, before he was even a year old, constant ear infections, bronchitis, and other respiratory issues.
Was your son in daycare at the time?
No.
I ask because sometimes it's common for kids to get sick when they're in daycare. What did you do as a result of seeing that your son was having these respiratory issues?
I took him to the emergency room.
And what was the result of going to the emergency room?
We discovered he had bronchitis, and he was given and a double ear infection, and he was given penicillin for that issue.
Okay.
Hold on one second. Mr. Douglas?
So I'm still having a hard time hearing the exchange, first off, but it sounds like there's like medical related testimony being given, and there's not a personal injury claim in this case. And so just for efficiency, I'm going to object on relevance. If this is a breach of contract, landlord-tenant statute claim, I don't know how this testimony is at all relevant.
Okay, let's do two things. First, as to the volume, if you'll move that microphone towards you a little more, the bass doesn't move, it bends towards you. You're gonna need to speak up, outside
Okay.
voice, whatever it is.
Okay.
And you can, the chair doesn't have wheels, so you don't roll off. So if you scooch the chair a little closer and then just make sure you're talking into the microphone, because the sound system works if you use the microphone. So please do that, both of you. Ms. Shackelford,
Yes.
there's a concern about the relevance, there's an objection as to the
Yes.
relevance of this, I'll call it medical testimony.
Yes.
Tell me how that's relevant to what we're working through.
Yes, Your Honor. This testimony is relevant because we are seeking punitive damages, and it goes to our claim of punitive damages of being subjected to living into that type of housing. Grady knew that there was mold in the housing, and so this testimony establishes why punitive damages should be assessed against them in regards that they were aware, they knew, and it goes to that willful conduct that we were mentioned in opening.
How are you establishing, or is that already something that's coming from below, that one, that there was mold? I've seen the reports, but two, that Grady was on notice that there was mold.
We will be presenting evidence further on right now of emails about the AC videos that they've seen, the mold report. So this was leading the way to get the rest of this evidence and
Okay.
videos.
Won't the issue with the punitive damages, though, be whether Grady willfully failed or refused to address the mold, as opposed to the existence of mold and the impact that the mold had on Ms. Simmons's kids?
So right now, at least what I'm trying to do is establish that there was mold.
Okay.
And that it did affect her children, and that she did bring Grady, she put them on notice, in that mold was never resolved by Grady at no point during her tenancy. And so the willful conduct then also comes in and saying that they would have addressed that. And it's even something that council is stating today that they have fixed, but to our knowledge, until she moved out in March, that issue was never resolved.
Okay. Mr. Douglas, you're familiar with the record from below. Is there a factual issue about whether mold existed in Ms. Simmons's unit? And I ask only not because I want you to admit anything, but if Grady's not contesting that mold was there, then we may be able to streamline some of this. But if there remains a dispute about the presence of mold in Ms. Simmons's unit, then we'll keep heading in this direction.
I recognize that this report was discussed at the lower court.
Right. It's in the record from below.
Right.
Yeah.
I object to it, though, as hearsay, given that there isn't anyone for me to cross-examine as it relates to the reliability, to the testing standards. That there's a ton of case law as it relates to reliability of expert testimony and expert documents. I have no way of questioning the Simmons about whether the standards that this company adhered to are widely recognized in the industry.
No, I understand all that. I will go back to my question, though, which is there a disagreement in this case about the presence of mold in Ms. Simmons's
So
unit?
Yes, because my client didn't perform an independent mold test. So yes.
Okay.
The short answer is yes.
Got it. Then you should keep going. So where we were was that your son had bronchitis and dual ear infections, and then we paused, and you'll speak up.
Yes, Your Honor.
Okay.
Ms. Simmons, did your son continue to have bouts of bronchitis or any other respiratory issues, or was it a one-time incident?
He continued to have respiratory issues throughout, until he was about 5, 6 years old.
Okay, so at 5 or 6, did he stop having them?
Yes.
Okay. What led you to believe that there may have been an issue in your apartment complex?
I had issues with my AC unit.
Maybe you're going to ask that. I don't know what you mean by like it didn't work or black smoke came out when you turned it on.
So I could hear water, and I saw water coming from the locked closet unit of the HVAC unit. And there was a time it did not work, and I contacted management.
Did your AC unit, you said HVAC, is it like the window mounted one or it's a full blown, like there are vents throughout your apartment and cold air blows through those because there's a central blower?
To my understanding, it was a central air conditioning unit.
Sorry.
So you had a thermostat in your apartment or more than one where you could say, I want it to be 72, I want it to be 75.
Correct. I had one thermostat in my apartment.
Okay.
And in fact, you did submit work orders to your apartment complex about this AC issue, correct?
Correct. I submitted work orders and emailed the apartment complex.
Counsel, you already have my exhibits from when we submitted them on Friday. But if you don't, let me know. I'm going to go a little out of order and show you plaintiff's exhibit 15.
Mr. Douglas, you did need to respond to me, but you've got all these exhibits, whatever we're talking about?
I did receive them. I'm not sure which one we're referring to now.
She said 15, so if you've got them, it would be number 15.
Do you need a copy?
If you have it.
Do we need to share our exhibits on the stream, Your Honor?
Depends. Give me a second. I'm having to log into Adobe so I can see stuff. If everyone has her own copy, you don't need to share them. But if there is someone who doesn't, then sharing is caring.
Okay. Mainly, I just want to make sure that Your Honor has a.
I think so.
Okay.
Adobe.
I have hard copies if you need them.
Being funky right now. Oh, I'm
Okay. Ms. Simmons, look at plaintiff's exhibit 15. Do you recognize this document?
Yes.
Can you describe for the court what this is?
It was an email to Natasha Bronner, alerting her of me calling in for an emergency work order because my AC unit was out.
And this was in May 9th of 2023?
Correct.
Your Honor, I'm going to move to tender plaintiff's exhibit 15.
Tell me, Ms. Simmons, who that person is to whom you sent the email, who that was to you.
I'm not sure of her title, but I know she worked in the office of Ashley at Auburn Point at that
So
time.
someone associated with your apartment complex.
Correct.
Okay. All right. Mr. Douglas, any objection to, I'm gonna call you plaintiff rather than petitioner, plaintiff's 15?
No,
Okay, that's admitted.
So as early as May of 2023, you were having AC issues. Was this the first work order that you submitted regarding your AC?
Yes,
After you submitted this work order in May, was your AC unit fixed?
not completely.
What does that mean?
So when maintenance came to the apartment complex, they told me that there was ice buildup in the drip tray. He said he broke the ice and he bent something inside the AC unit for as a temporary solution, but they were going to permanently fix it.
I'm gonna object on your side, ground side.
Got it.
So you can't testify to what someone said. You can testify to what you heard or how you reacted, but you can't testify to another person's statements. You can only testify to your knowledge, okay?
Right, and what your lawyer said was a little confusing. You actually cannot testify to what you heard because what you heard was what someone else said. So your lawyer would need to bring in
Yes.
maintenance guy to say, there was ice buildup and I bent the pipe. If he told you that, that's what you heard, but that's the part that Mr. Douglas was properly objecting to. So you didn't do anything wrong. You were answering the question. Ms. Shackelford will probably ask the questions a little bit differently or cut you off if you start to say, oh, that's when the maintenance man told me, ... and we'll go from there.
What did you do in response to maintenance not fixing your AC unit?
I reached out to Natasha Bonner again in regards to the leaks, the sound of water running through what I was hearing from the HVAC unit.
Okay. Now, when you emailed your apartment complex in May, you also sent them some pictures. We're looking still at Plaintiff's Exhibit 15. And this is in that email chain. Look at page 2. What are those pictures that we're looking at?
This is by the entryway, between the entryway door and the HVAC unit locked closet.
Okay. And what exactly is the picture? Like what is that markings on the wall?
It was it was what I assumed to be mold. It was black buildup
Okay.
in the corner of the doorway, doorway in the HVAC unit.
Okay. And then if you turn to page 3, they're a little grainy. What are those pictures that you sent to Auburn Point?
So I noticed that there were, black and gray spots growing in my daughter's bedroom closet.
Mm-hmm. Is that what we're looking at in those last 3 pictures?
Yes, this is my daughter's bedroom closet.
So I'm going to show you what's marked as Plaintiff's Exhibit 3 if you want to switch to tab 3 in your binder. Do you recognize these pictures?
Yes,
Are these the pictures that we were just looking at in Plaintiff's Exhibit 15?
part of them, yes.
There are 3 lines of pictures. What's that first longer picture of?
That is the entryway door,
Mm-hmm.
between the entryway door and the HVAC unit closet.
Okay. Did you take these pictures?
Yes,
Are these true and accurate pictures of what you took?
yes.
Your Honor, I move to tender Plaintiff's Exhibit 3.
Any objection, Mr. Douglas, to plaintiff's 3?
No objection.
Admitted.
So you testified earlier that you thought this was black mold. So the black here in the corner of this first picture, that was the black mold that you're referring to?
Yes.
What's the second picture in Plaintiff's Exhibit 3?
It was moist kind of like water. This was on the other side of the HVAC unit closet. It was between a wall and the door of the HVAC unit closet, and it was like some sort of moist water and little specks of what was on the other side of the doorway, the little black mold.
And there's a third picture. Can you describe to the court what that third picture is depicting?
More moisture, more what appears to be water.
Were these issues ever fixed?
No.
Besides
Ms.
those,
Simmons, the pictures that we see here, are any of them taken from inside the HVAC closet? Or this is in what I'd call like publicly accessible space? Like if I'm standing in your apartment, you've invited me in, can I see all these things or do I have to be in some closet?
They were in publicly access space.
Okay. I don't mean that the public comes into your apartment, but this is space that you or your kids would be in.
Correct.
Okay.
and to that point, there were other areas of the home that had similar issues. Is that true?
Correct.
Was one of them your daughter's room?
Yes.
Where did you see these issues in your daughter's room?
It started out in the closet, her bedroom closet.
Turn to plaintiff's 4. Do you recognize these pictures in plaintiff's 4?
Yes.
Did you take these pictures?
Yes.
Can you tell me what these pictures are of?
It was the spread of the black and gray spores all over her closet.
Your Honor, I move to tender plaintiff's exhibit 4.
Mr. Douglas, any objection to plaintiff's 4?
No objection to the exhibit. I will object.
You object to the word spores? Okay, understood.
This is qualified.
She's going to describe it as she does. I appreciate that Ms. Simmons was the occupant, not the mold expert. Ms. Simmons, the closet looks like it doesn't have much up on the shelves. Was that because your daughter couldn't reach up there, or you didn't want to keep things up there, or why?
When I noticed this, what it was that
Call it sport, you can call it whatever you want.
the black spores, the mold, what I thought was mold, I removed everything from her closet.
Okay, so you emptied it when you saw whatever this is on the walls.
Yes.
Got it. Where did you have to put all your daughter's stuff?
Her clothes, I had to purchase a rack to place outside of her closet. Everything else was just kind of piled around her room because there was no other storage space to put her stuff.
Okay. And these pictures, all of, I assume we're going to see more, but exhibit 3, exhibit 4, were they taken around the same time or different times?
Different times.
When were these photos of your daughter's bedroom closet taken?
Around August of 2024.
So less than a year ago.
Correct.
Ms. Simmons, had you put Grady, and I'm sorry, I keep going back and forth between Grady and the name of the complex. Had you put them on notice about your concerns about your daughter's bedroom closet?
Yes.
When did you put them on notice?
There was multiple times. The first time when, there's several different pictures here and different times that I've taken them. But the first time was with Natasha Bonner, back when I noticed the mold in 2023.
Mhm.
And then again, when I notified them that the mold repair hadn't been made in my apartment per the consent agreement.
So you notified Grady in 23 that you were concerned about mold issues. Did they ever come and fix any of those mold issues?
No.
In 2024, are you saying that they had noticed that you were still concerned that there was mold in the apartment?
Yes.
In 2024, did they ever come into your apartment and fix those issues?
No.
Did they ever come into your apartment between 2023 and 2024 to fix any of the issues you've complained of?
No.
You moved out in March of 2025, correct?
Correct.
When you moved out in March of 2025, had they come and made any repairs to the apartment?
I believe it was in January, after, like the end of January, beginning of February, a contractor came and, replaced some drywall. That was it.
Where did he replace drywall?
By the HVAC unit area, inside the HVAC closet, and my daughter's room, the wall in my daughter's bedroom closet.
Okay, the
So
wall,
two places, the HVAC closet and then this closet that we see in plaintiff's 4?
Correct.
did they do anything to the roof?
No.
When you say roof, you mean her ceiling or I
Yeah,
don't know if
sorry,
you have
I'm
a
sorry,
first.
the ceiling, yes, the ceiling
Okay.
that we're looking at in the top corner of P4.
No.
Besides where the AC unit was and your daughter's closet, were there also other areas of the residence that had issues?
My bedroom closet. And it continued to progressively come out into the living room area, all over my furniture, all over clothes, in the kitchen, and in the hallways of my home.
When you say it, what are you saying?
The black, the black dots, the spores.
Okay, whatever the black stuff is,
Yeah.
you said started to appear on furniture, was on walls, was in the kitchen.
Correct.
Okay.
Turn to plaintiff's exhibit 5, please. Do you recognize these pictures?
Yes.
Tell me when, well, let me ask, strike that. Did you take these pictures?
Yes.
When were these pictures taken?
In August
Of,
August of 2024.
and what are these pictures of?
They're my bedroom closet.
Okay. Your Honor, I move to tender plaintiff's exhibit 5.
Any objection to plaintiff's 5?
No objection.
Admitted.
So I'm bringing my attention to the first picture in P5. It looks like the ceiling of your closet. When did you start noticing that those black spores on your ceiling closet?
In August of 2024.
And did those spores continue to spread in your closet?
Yes.
Now, you said that a contractor came in January of 2024, or excuse me, January 2025. Did he make repairs to your bedroom closet?
Not that I'm aware of.
When you moved out in March of 2025, are these spores still present?
Yes.
Turn to plaintiff 6. Do you recognize this picture?
Yes.
Can you tell me what this picture is?
This is my bedroom closet.
Same closet we were just looking at?
Yes.
So safe to say you took this picture.
Yes.
Your Honor, I move to tender plaintiff's exhibit 6.
Was the picture in plaintiff 6 taken around the same time, August 2024, as what we saw in plaintiff's 5?
Yes.
Okay. Mr. Douglas, any objection to plaintiff 6?
No.
Okay, it's admitted also.
So you're saying that the spores were traveling throughout your closet. So here I see at the bottom of plaintiff 6, there's a wall and there looks to be some black spores going down the wall. Is that the spread that you were referring to?
Yes.
When you moved out in March of 2025, were these black spores throughout the entirety of your closet?
Yes.
Were they in your sleeping area?
Yes.
Turn to plaintiff's exhibit 7. Do you recognize this picture?
Yes.
Is this again a picture of your closet?
Yes.
When did you take this picture?
August of 2024.
Move to tender plaintiff's exhibit 7.
Do you want to, I don't know if you want to go 7 through 10, just do, rather than going one by one, if they are all of the same closet
Yes.
and are documenting a similar phenomena, if you want to see if you can lay the proper foundation for them, which you've been doing fine so far, we could see if there's any objection to 7 through 10.
Okay. So then turn to plaintiff's exhibit 8. Do you recognize this picture?
Yes.
Did you take this picture?
Yes.
What is this picture of?
It's my property. It's a pillow that had the same appearance of what was growing everywhere else in the apartment on the pillow
Where was this pillow?
in my bedroom closet.
And when did you, I may have asked you this, when did you take this picture?
August of 2024.
And then turn to plaintiff's exhibit 9. Do you recognize this picture?
Yes.
What is this picture of?
This is my bedroom wall.
Okay. And did you take this picture?
Yes.
When did you take this picture?
August of 2024.
Your Honor, I move to tender plaintiff's exhibit. I think we already have
You had 6 in, so
Okay.
it's 7 through 10.
7, 8, and 9.
Oh, you're just doing 7, 8, and 9?
Yeah, I think that I'm missing a 10.
Okay. I mean, I've got a 10, but I won't consider
Okay.
10 if you're just doing 7, 8, and 9.
Oh, I do have 10. And then turn to plaintiff's exhibit 10.
I don't have a 10.
Well, then we won't do 10.
Do you?
Needed that.
I think our manager service. Do you recognize that picture?
Yes.
What is that picture of?
These are my clothes in my bedroom closet.
When did you take this picture?
August of 2024.
I'll move to tender 7, 8, 9, and 10.
Mr. Douglas, any objection to 7 through 10?
No, Judge.
They're all admitted.
So when you were living in the apartment, at any point, did you have an examination done on the apartment?
Yes.
Tell me about that. What kind of exam did you have done on the apartment?
So I had a mold. I had a mold examination. Somebody came in to test for mold.
Okay. Did they give you any type of report?
Yes.
Did you review that report?
Yes.
Did someone explain that report to you?
Yes.
What was your understanding of the results of that report?
Objection. I don't know that foundation has been laid sufficient for Ms. Simmons for her understanding of the report to be admissible as what the report purports.
Plus, there's a hearsay angle to this. How would Ms. Simmons's understanding of the report be anything other than she read it, which she's entitled to do, and then she's going to say, "Judge, it says there was mold in my apartment." I mean, it says whatever it says. I haven't read it, but how is that not hearsay?
Well, I think that she can testify to her understanding of what she thought was going on in her apartment, which then caused.
She's done that. She's definitely done this. She called it spores. I've seen the picture. Something was going on in her apartment. Something that doesn't look good and certainly needs to be addressed. Is it mold or not? Is it mildew? And I don't know because I don't operate in that sphere. Is there a difference between mold and mildew? None of it should be there. Just letting everyone know right now. None of that should be there. No one should have to live with the closet looking like that. But what I'm hearing the objection to be is that report has some nuggets in it. Hey, it was dangerous. It was this, it was that. The person who wrote the report could be here so that Mr. Douglas could say, how did you reach that conclusion? And did you use a mass spectrometer or a thermometer or a ruler or your nose? Ms. Simmons survived being there, but she's not the one who generated the report.
Right.
And so she would be saying basically, I think it means X. And I don't know that she's the right person to say, let me tell you what the report means.
Right. Not so much about how much the report means, but how she reacted in a result to it and what she did after getting.
Well, then you should ask that. Based on the report and your understanding of the report, what did you do next? And we'll see if there's an objection to that,
Okay.
which I'll probably overrule if there is.
Okay. Excuse me. So after you received the report, what did you do after receiving that report?
I sent it to the apartment complex.
Did you, Ms. Simmons, hire, I don't know who prepared the report, whomever, Dr. So-and-so, did you bring that person in or did the apartment complex do that?
It was the Atlanta, the lawyers. For
AVLF.
AVLF, yes.
They helped identify a subject matter expert.
Yes,
Okay, and that person came and did whatever, was it a he or a she?
it was a man.
A man, okay. So he did whatever he did, generated a report, and you received that report and sent it to Grady Multifamily.
Correct.
Got it. Thank you. Did you keep a copy?
Yes, I kept a copy.
Okay.
Turn to plaintiff's 11. Yes, yes.
Okay.
You can object. Go ahead.
Yeah.
Because I mean, she's not testifying that the facts within it are true. She's testifying that this will be the copy that she received. But I mean, we can move on.
You can ask her the questions, and when you seek to tender it, Mr. Douglas will have an opportunity to say what he wants to say, and then I'll let you know what we're going to do.
Look at plaintiff's 11.
Yes,
Do you recognize that document?
yes,
Is this the document that you received?
yes,
Is this the document that you reviewed?
yes.
What is this document?
It's the mold report.
Is this the document that you also sent to Grady?
Yes,
Move to tender plaintiff's exhibit 11.
Before we wrestle with that, Ms. Simmons, this gentleman that AVLF helped you find, the mold expert, we'll call him that, he actually came into your apartment
yes,
and did whatever he did, took pictures, measured things, whatnot.
yes,
Okay, and then generated this report.
yes.
Okay, all right, Mr. Douglas.
The report itself is inadmissible hearsay under Maloof versus Metro Atlanta Rapid Transit Authority, which is a Georgia appeals case from 2015. And so I'm going to object to.
Tell me what Maloof says. I haven't memorized all the Court of Appeals cases. Why is Maloof something that would keep it out as opposed to it's hearsay?
For a number of reasons, but the primary one is that the person who produced the report, again, as Your Honor has identified, as I identified earlier, is not here for me to question regarding the reliability of those results.
Okay. And Ms. Shackelford, you are seeking to admit this for the validity of the contents of the report or for some other reason?
No, Your Honor, I'm not asking you to take this report and say that you're going to find that this report is completely reliable. The testimony was that this is the report she received, reviewed, and then sent to Grady. So it's for the purpose of showing that Ms. Simmons reached out to Grady, put them on notice, and then there was no repairs done after. So irrespective of whether or not the court says, yeah, I believe this report or not, it's a document that was given to Grady and then caused actions as a result of being given this document.
Okay. So what I'm going to do is accept Ms. Simmons's testimony that She obtained a mold report and gave a copy of that to Grady. So whatever's in the report, Grady was on notice of. And so Grady can say, and we hired our own expert, or we did nothing, or whatever they did or didn't do. And we'll go from there. So I will not admit plaintiff's 11.
So after you sent the report to Grady, did they come and repair and make any repairs to your apartment?
No,
So how did a contractor end up in your apartment in January of 2025?
it was after the hearing.
So,
When the report that's not admitted, I notice has a date of July 2024 on it. So you wouldn't have had it before then. When did you, Ms. Simmons, get it to Grady Multifamily?
In August.
Okay. Oh, sort of like when you're taking these pictures as well. There's a lot going on in
Yes.
August. Thank you.
so you testified that a contractor didn't come into your apartment until January of 2025. Is it your understanding that, or is it your belief that they didn't come to your apartment until they were under a court order to?
Can you repeat that?
Sure, I'll rephrase. Why do you think, in your opinion, Grady came?
I can't hear the question, I'm sorry.
Why do you think, in your opinion, Grady finally came to your apartment in January of 2025?
Objection.
Your opinion?
The basis of the objection
How,
calls for speculation.
yeah,
Calls for speculation. Maybe Grady told her one of the things you can talk about is what people from Grady said to you. I know that we said, wait, don't say what other people said. But if Grady said, we're not coming because we don't like that report, that's the kind of thing you can share. But I think it is speculative to ask Ms. Simmons, why do you think Grady didn't do anything until whenever? You can argue that, like, oh, it's interesting that Grady does nothing. Then there's an order, and then all of a sudden they spring to life. But it also could be Grady had a change in property managers.
So I'll rephrase. At no point until January of 2025 was what we are calling as mold repaired in your apartment, correct?
Correct.
When did Grady tell you that they were sending a contractor to do some drywall repair?
They didn't tell me anything.
Then did you have to let a contractor into your home?
Yes.
He just banged on your door and said, I'm here to do stuff?
Yes.
When did this happen in relationship with Grady seeking to evict you, before or after? Because I thought that was January of this year as well, that they took out what we call a dispossessory, which I'm calling evict. You should use whatever word you've been using.
It was after.
The guy to fix the walls came after they said you need to move out.
Yes.
Okay.
I'm gonna jump to Plaintiff's Exhibit 14, which I know you're not gonna have a copy of, so I need to screen share, Your Honor.
I'm not going to have, or
Because
Ms. Simmons
it's a
will.
video.
oh, okay. How are you going to play the video before you admit it?
Ooh. Okay,
Is it something that, well, I'm going to let you navigate that. Just don't play it if it's not in evidence.
did you ever take videos of the AC unit?
Yes.
Describe that video to me. Where did you take it? Like, was the video at night? Was it in the day? Like, what were you taking a video of?
May I explain how the closet was opened?
Sure.
So, someone came at sometime in October to replace an air filter.
This is October of last year, 24?
Yes. When they opened the HVAC closet, it was filled with all the black stuff that was by the entryway door. And he took out the filter. It was bent and distorted and full of black and gray soot all over the filter. I asked the gentleman, well, I mean, I don't know if it's here, but I asked him when it had been changed, and I don't know if I can respond to.
Just keep talking until someone
I
objects.
asked when the filter has been changed. He told me it wasn't one of his filters and he hadn't changed it.
Okay,
So,
sustain.
you took a video of your AC unit and that is my exhibit. Let me ask you, do you recall you took this video in 2023, 24, 25?
2024, when I finally had access to the closet.
So you had a closet in your apartment that you could not get into?
Correct. It was a locked door for the HVAC unit.
Okay,
And the key that I had did not open that door.
but this repair guy who shows up in October, he's able to get in there
Yes.
to replace the air filter.
Yes.
And you are now, for one of the first times ever living in there, getting eyes on what the heck's going on inside that closet.
Yes.
And this is what you filmed.
Yes.
Okay.
Your Honor, that's my plaintiff's exhibit 14, which I move to tender, and I believe counsel has had the opportunity to review it because we submitted all of our evidence and on Friday.
Okay. And you said this is 14?
Yes, Your
Any
Honor.
objection to plaintiff's 14?
No.
It's admitted.
I'm gonna try to screen share so we can all watch the video. I am not sure I have the capability of screen sharing.
I can do it.
Okay.
Is it on your screen now?
Yes.
Yes. What should I put here?
Stay muted. Okay. Here we go. You want me to play it?
Yes, please, Your Honor.
On your screen now?
Yes.
Yes. What should I put here?
Stay muted. Okay. Here we go. You want me to play it?
Yes, please, Your Honor.
On your screen now?
Yes.
Yes. What should I put here?
Stay muted.
Okay, so the video. Yes.
What should I put here?
Stay muted. Pause it. Okay. You
So
can
this
talk.
is the video that you took when the closet was open for the first time, correct?
Yes.
And these are the same types of black markings
You
that
can-
you.
you
So
can
this
talk.
is the video that
Hold on
you
one second.
when the closet was open.
I think I can fix this. All right, keep talking.
Okay, so these are the same type of black markings that you were seeing on the rest of your apartment, correct?
Yes.
You want me to keep playing it?
Yes, please.
Is this the first time in the 10 years you've been living there that you were in that space?
Yes.
Had you like knocked the repair guy out? That's how you got in here? Or how were you able to be in this closet?
I asked them to keep it open so I could take the video.
That the new air filter?
Yes.
That's the corner we saw in one of your still
Yes.
photos?
So you said that that door where the AC unit was locked, correct?
Yes.
Um, when did you know that you needed to change out your air filter?
I didn't.
Were you supposed to submit requests to change out air filters?
Not to my understanding.
So what caused someone to come in and change the air filter?
I don't know.
What's the question? I'm sorry.
What caused someone to come in and change the air filter? And her answer was, I don't know.
Now, in fact, there was more than just the mold issues that were at issue with the apartment, right?
Didn't hear that question either.
I need you to stay near the microphone or belt it out.
There were more issues with the apartment complex than just the mold.
We haven't established that there was a mold issue, but
Or
What
in your
we're referring to
opinion,
as the mold issue, those dots all over the apartment, the black stuff, we're gonna call that mold for shorthand. I'm not making a finding that it's mold or asbestos or arsenic or whatever, but that black stuff we'll call mold. There were issues beyond mold.
Yes.
can you tell the court what other issues you were having with the apartment complex?
Just general upkeep of the complex. There was several times that the trash in the dumpster would overflow out into the parking lot. There are rats all over the place. My children couldn't use the playground because it was broken down and unrepaired. It just the entire community just had declined.
So this is your opinion, right?
Yep, since the 10 years since I've lived there, it's just completely declined.
Did you ever let Grady know that you were concerned about the sanitary conditions of the
Yes.
apartment? Did you ever take videos of your concerns?
Yes.
Your Honor, if you will pull up plaintiff's exhibit 12.
So we need to lay a little more foundation before I start looking at anything.
Okay.
But hold on. Yes,
And I'll
Mr.
just raise
Douglas.
that none of these issues were raised in the lower court. This is all new stuff.
And we're a de novo proceeding, so
Okay.
here we are.
So you took videos, right?
Yes.
Can you tell me when you took these videos?
I want to say it was ongoing, but I want to say it was around 2023. I may have took the videos of the that you're referring to, if I believe.
Can you describe what those what kind of videos were you taking? What were they?
There's a number of videos. There was one video where I'm just the condition of the hallways, the outside of the overflowing dumpster, the large rats running amok during the day, just the overall condition of the area of where I lived.
Does the video show raccoons pillaging through
It
garbage?
showed rats,
Rats.
large
Okay.
rats pillaging through
Um,
the garbage.
Does your video show feces on the ground?
Yes.
When did this video, it sounds like you were sort of a videographer for the place, but whatever we're gonna look at, what's its date?
Pardon?
The video that, is it one video? I don't know. This sounds like it's
There's two.
a collage. So these two videos,
Mhm.
when did you take those videos?
But both took place in 2023.
So they're a
they-
couple of years, they're older than what we've been talking about with the August of 24, October 24, January 25. The things that you're talking about, the film you made was from 23.
Correct.
Okay.
But I do want to be clear, I also reported the HVAC unit leaks that I had in 2023 as well.
Okay. Yeah, you said May 23. That's your email, Exhibit 15.
Before we try to review the videos, look at Plaintiff's Exhibit 20.
Yes.
Was the garbage overflow an ongoing issue?
Yes.
Were these sanitary issues that we were just discussing an ongoing issue?
Yes.
And you said that you had reached out to Grady. Do you recognize this document in Plaintiff's Exhibit 20?
Yes.
Can you describe for the court what this is?
It's an email to Miss Brunel.
I think it's Bunnell.
I'm sorry, Miss Bunnell, in regards to the excessive dumpster overflow that was ongoing in the neighborhood.
And what were you asking for Ms. Bunnell to do in this email?
To make corrections, I noticed the apartment complex comprises of different areas. There's one area near the leasing office that I would have to take my kids over to play in the park because it was nicer. And then there was our area in which I was a tax credit unit.
What does that mean?
It was a subsidized unit, and I guess HUD was providing for working people reduced rent. And I noticed in my side of the complex that this ongoing trash issue continued that I didn't notice on the other side when I took my kids to swim in the pool and play in the playground over there.
And when you noticed this trash issue, you said that when you took the videos in 23, you noticed vermin. Were there also vermin present when you sent this email?
Yes.
And did you take pictures?
I can't, honestly, I can't remember. I remember taking videos, but I can't remember if I took vermin. I remember there was may have took a picture of a video of a dead rat that had been there for weeks and hadn't been cleaned.
Your Honor, I'll move to tender Plaintiff's Exhibit 20.
When did you send that email to Ms. Bunnell?
I'm sorry. I see the date says 2024. Maybe because it was the beginning, I thought it was 2023, but it looks like January 23rd, 2024.
Okay. Any objection to plaintiff's 20?
No.
Okay, it's admitted.
So in Plaintiff's 20, there are
And Ms. Bunnell, how would we say her name? Your understanding was she was part of property management.
Yes.
there are four images that you attached to your email in Plaintiff's 20. Is that the overflow that you're talking about?
Yes.
Is that where you also, when you say vermin, what exactly do you mean?
Rats.
And is this in line with the videos that you were talking about earlier?
Yes.
Your Honor, I'll move to tender and plaintiff's exhibit 12 and 13, which are the two videos that Ms. Simmons took.
Okay, any objection to plaintiffs 12 or 13, Mr. Douglas?
No, Judge.
They're both admitted.
I want to start with, if Your Honor would like to view plaintiff's exhibit 12 first.
Meaning you want me to play them?
Yes, Your Honor.
Okay,
I
hold on.
don't, my Zoom doesn't have the ability for me to share screen. Oh, yes, it does now. Okay, I can share.
Okay, see what happens. It's pretty teeny. Can you make it
Here we go.
cute? The hoop?
Yes.
I'm going to let the video play and then I'm going to ask you some questions about it, okay?
Okay.
What is that?
It's a dead rat.
Very dead rat.
Okay, so in this video, you start off in a hallway. Where are you at the beginning of this video?
I was coming out my apartment.
So right when you walk out of your apartment, there was feces on the ground?
Yes.
Was this the first time that you had ever seen something like that?
No.
Later on, we see that there's more feces at the bottom of the stairs. Was this the first time you ever had encountered feces in a public walkway?
In the apartment complex or in general?
Yeah, in the apartment complex.
Yes.
And then you walk out into the parking lot of your apartment complex and there's a dead rat. Was this the first time you had seen a dead rat there?
No.
Now I'm going to show you plaintiff's exhibit 13. Give me a second. What are you zooming in on there?
Maggots.
Was that garbage area that we saw? Sorry, I keep walking. Was that garbage area that we saw right outside your building?
Yes.
Now there was two. There was one that kind of looked like it was back on the side of a building where it had a trash bag hanging down and garbage overflowing. What is that area of the apartment complex?
That's the trash compactor.
Okay. And so then there's another dumpster. Was that dumpster routinely there?
They would bring it there routinely. It was something that wasn't always there, but was placed there eventually.
And so then we see maggots by that dumpster. Was that the first time you had ever seen maggots?
No.
So the unsanitary conditions, not just inside your apartment, but outside, was common.
Yes.
Had you expressed concerns to management about these unsanitary conditions?
Yes.
When were they fixed?
It took them years before the trash situation was fixed, but right before I moved out, they placed another dumpster on the other side of I don't have pictures of it, but there was another dumpster placed on a large dumpster placed on the other side of the apartment complex. So it was a regular ongoing situation.
Okay. So when you moved out in March of 2025, were you still seeing rats?
Yes.
Were you still seeing maggots?
That not by that dumpster, but the other dumpster, yes.
Were you still encountering feces on the ground?
Yes.
That, oh, were you able to tell? I don't want you to speculate. Was it dogs or people? I mean, it's too big to be rats.
I can't determine that. I'm not sure.
All right. Not that you would want to check it out, but I just was like, did
I
people
don't
just,
know if they were even human. It's like it was very large.
but would people just not take care of their dogs in a responsible way? Or you don't know because you weren't watching for people to be leaving that around?
I'm not sure. Like I said, to me, it appeared to be human.
Okay.
So I'm going to backtrack just a little bit. We've talked about the unsanitary, in your opinion, the unsanitary conditions you were living with in the home, and then the unsanitary conditions outside of your apartment complex. But the issues with the AC were also a concern for your children, right?
Yes.
It gets hot in Atlanta, doesn't it?
Yes.
Did your AC work in the summer?
Periodically, yes.
Were you and your children subjected to heat because your AC didn't work?
Yes.
And in fact, you told Grady of this, didn't you?
Yes.
Look at Plaintiff's Exhibit 15. Do you recognize this email?
Yes.
When was this email sent?
It was sent May 9th, 2023.
What is this email about?
It's contacting Miss Bonner about an emergency work order that I submitted because my AC unit wasn't working. The office told me that it was not an emergency, so I emailed Miss Bonner about the situation, letting her know how hot it was outside and that I have two children in the apartment and it does not have working AC. And it was my second time putting in a work order for my AC unit. And I was surprised that I was being told it wasn't classified as an emergency.
So not only have you contacted Grady about the leak, but now you're also expressing to them, this is a concern because it's 87 degrees out and I have two kids living with me.
Yes.
I'm to tender Plaintiff's Exhibit 15.
The date of that was, you said May of 23?
Yes.
Okay. And that's 15?
Yes, Your Honor.
Any objection to plaintiff's 15?
I believe it was already admitted, Your Honor.
Maybe so. I don't, but yes. Yep, that's in. It
Oh, okay.
was the first thing you admitted. But it's in twice now.
Okay, well, good. So we've talked about how you continually put Grady on notice of these ongoing issues from 23 to 24. Turn to Plaintiff's Exhibit 17. Do you recognize this email?
Yes.
What is this?
So it's an email after we submitted the consent agreement. I was contacting Dion and I CC'd
Let me stop you.
Tamarcus.
Who's Dion?
I'm sorry, she was somebody else that worked in the office and Tamarcus another person. It was the two people that I was in communication about the consent agreement, and to do the mold repair.
And when was this email?
August 9th, 2024.
I'll move to tender plaintiff's exhibit 17.
Any objection to 17?
No objection, Your Honor.
Admitted.
So in this email, you're talking about the May 5th, 2023 emergency work order of the AC unit, which we just talked about, and along with your ongoing issues. After this email, was anything in your home repaired?
No.
So there was also pursuant to that consent order, you were supposed to get a reduction in your rent.
Yes.
Tell the court, how much of a reduction were you supposed to get?
I know my rent was supposed to be reduced down to like $500 and something dollars. I can't remember the exact amount.
Was your rent balance accurately reflected with that rent reduction?
No.
Did you contact them to let them know that this was not an accurate reflection?
Yes.
Turn to plaintiff's exhibit 18.
Before you do that, Ms. Simmons, tell me your understanding of this consent order. First, what was the process? Did you go to court?
So yes, I went to court regarding because they applied a rent increase. They prematurely applied a rent increase for my new rent. So I went into mediation with the landlord.
Mm-hmm.
Once the consent agreement was made, we went before the judge and it was made into an order.
Okay, and that was Judge Drake?
No, it was a different
Judge. Okay. And did you have a lawyer for that, or were you representing yourself?
I was representing myself.
And there was a lawyer for Grady.
Yes.
Was it Mr. Douglas?
Yes.
So you've dealt with Mr. Douglas the whole
Yes.
time? So you and Mr. Douglas reached some agreement that would address the concerns that you brought before the mediator and ultimately the judge?
Yes.
And the result of that was that your rent was being reduced?
That my rent would be reduced and the mold would be repaired.
Okay, so your understanding of it is that, and I'm assuming it's in the record and we'll work through it, but that there was a directive to Grady to do some, I'm gonna call it remediation,
Yes.
clean things up at your apartment, but also that the amount you had to pay in rent went down.
Yes, for September's rent.
Just 1 month?
Yes.
Oh, why just 1 month?
Because it was the impression that the mold would be repaired.
Oh, so as long as well, it probably didn't say this, but as long as the condition persisted, you would pay the reduced rent.
Correct.
But it was supposed to be fixed in that 1 month.
Yes.
And so it was just 1 month of
Yes.
reduced rent.
Yes.
Interesting. Okay. That's your understanding of what the order was.
That's my understanding. Yes.
Okay. You get to clear it up. I just want to understand Ms. Simmons's understanding of it.
I guess I can do it in closing because my witness was not, I don't have anyone that was present during that time.
Is there not an order?
Procedurally, that's not at all what happened.
Oh, okay, but is there not an order or an agreement of some sort?
There it is.
Okay.
I think just for background, this was in connection not with a claim that Ms. Simmons brought, this was in connection with a dispossessory filing. And this was the product of a negotiated, mediated agreement
Okay.
on the dispossessory.
And I'm much more focused on what the contents of the consent order was as opposed to how did you all end up there? But I'm now understanding different recollections as to why were we in front of a judge or a mediator to begin with?
That's what I wanted to clarify,
Got it.
Your Honor, that we
Okay.
weren't there as a result of, we were there as a result of a dispossessory filing
Okay.
by the property.
Do you agree generally with how Ms. Simmons characterized what that consent order was?
I don't.
Okay.
There was a
So-
reduction in the rent, not because of any mold or anything like that. There was a reduction in rent, and the order speaks for itself, but it says,
Is the order, I just want the order.
We can jump to plaintiff's exhibit 21.
Let's do that.
Which is the consent agreement. Do I need to lay, I feel like we've talked about it at length and it's part of the,
No, I can take judicial notice of it, so you don't need to, it's
Okay.
part of the county court's docket. So why don't you tender 21 and then you can ask
I'll
questions about it.
tender plaintiff's exhibit 21.
Any objection to plaintiff's 21?
No.
It's admitted.
So, Ms. Simmons, I'm looking at the verbiage contained here in the consent agreement. There's been a lot of discussion about whether or not there was mold in the complex. So I'm gonna read verbatim the line that says, "The landlord will make the necessary water and mold repairs by August 30th, 2024. You agree with that, right?
Yes,
So they agreed that there was mold repairs that needed to be done in the apartment complex or in your apartment, right?
yes,
So then it says that you dismiss your counterclaim without prejudice and that you would make payments via money order and the landlord will waive the $30 transaction fee. So you were gonna have a rent reduction and like you were saying, this is because mold repairs were supposed to be done by August 30th, 2024, correct?
yes,
So your rent had been 1133 and it went up to 1267. And you were arguing, Ms. Simmons, that increase was supposed to kick in July, but it kicked in June.
correct.
Okay. It also looks like you had some past due rent. That's the part of what you're agreeing to pay.
Yes,
Okay. And your past due rent, did it have to do with the difference between the two amounts, or regardless of whether your rent was 1133 or 1267, you were having trouble paying it?
no, I didn't have trouble paying it. They didn't correct my June rent. So I didn't pay the June rent because they didn't make that correction. They charged me the 1,267. I contacted them and they didn't make that correction for me to pay the proper June rent.
Got it. So
So-
you paid zero when you got a bill for 1267. You said, that's not my rent, it's 1133. And you paid zero because you had a disagreement. And so that 2,000 that has to be paid by August 2nd of 2024, a big chunk of that is the June rent that you never paid because there was a dispute.
Yes.
Not that times are tough, can I pay 500 this month?
So the apartment complex has what flex. It's
That was in your email. There's something in your email
yeah,
about
so
flex this.
So they offer flex payments where you pay where flex, I guess they pay your rent and then you pay flex, payments. So I got a notification from Flex that there was a discrepancy in making the payments because it all communicates with, the system for the apartment complex. And that's when I reached out to the apartment complex to let them know about the issue and they never corrected it. So I didn't pay rent. I didn't pay the June rent.
Okay.
So to that point, you said you reached out to them and sent them an email. So I want to go back to where we were of plaintiff's exhibit 18. Or I think, was I on 8? Your Honor, have I already tendered and admitted plaintiff's exhibit 17?
Yes, 17, not 18.
Okay. So do you recognize plaintiff's exhibit 18?
Yes.
What is this exhibit?
So this is an email that I sent in regards to a balance discrepancy after after our consent agreement. I had been making the payments and submitting the payments, but I received a notice that I was past due on the original amount prior to the consent agreement. So I was reaching out to them to correct that ledger to reflect not only my payments, but the agreed amount that we had agreed to in court to pay.
And this was on August 9th, 2024?
Yes.
And did they respond to you?
No. Not to this email,
Okay.
but I had approached, I saw Tamarcus outside. I had gotten, I don't know if I'm jumping, but I had gotten a dispossessionary for August.
Mhm.
And I approached him, questioning him about it, asking about it, because I had been submitting my payments for August rent. And I approached him on the way to filing an answer.
So you had rent that was due and you approached the complex to say this isn't the right amount of rent, correct?
Correct.
And then after you approached them, then they filed a dispossessory action against you?
Yes.
I'd like to tender plaintiff's exhibit 18.
Any objection to plaintiff's 18?
No, Your Honor.
It's admitted.
So you're going through this dispossessory action in August and you're still having maintenance issues, correct?
Yes.
And so you again send another maintenance request, I believe in October, true?
Yes.
Do you recall, turn to plaintiff's exhibit 19. There's a few pages there.
I'm sorry. Okay. Yes. Which page would you like me to look at?
You can look at the first page.
Okay.
So, well, actually, I think it's the one with the sticker on it, plaintiff's exhibit 19. So you sent another request October 3rd, 2024.
Yes.
What was this maintenance request for?
Oh, so this is actually an email about like a contractor coming to perform a quarterly preventative maintenance on the AC.
Oh,
So-
so this is a notice you received.
Yes.
Okay. In October, do you recall any repairs being done to your AC?
Only that's when that contractor did come and replace that
That's when you
filter.
got to take the video.
Yep.
Tender plaintiff's exhibit 19.
Any objection to plaintiff's 19?
No, Your Honor.
Admitted.
All right, Ms. Simmons, we've talked in length about what you believe to be mold and which is what was stated in the consent agreement that mold repairs were to be done. I just want to make sure that the record is clear. When you moved out in March, were those issues still present?
Yes.
Nothing further, Your Honor.
All right. Mr. Douglas, do you have questions for Ms. Simmons? And while he's getting up, Ms. Simmons, did you leave at the beginning of the month or the end of the month when you moved?
Towards the beginning of the month.
Did you pay for whatever part of March you stayed there? Or how did you work that out with Grady?
So they hadn't even, after the January hearing, and there was supposed to be a rent reduction, they hadn't applied that to my balance or my ledger either.
When you say there was supposed to be a rent reduction, I've seen what's in the consent agreement from July of 24, and that was a one-time rent reduction. But you're saying as a result of the hearing in January, was it a permanent until the issues are addressed rent reduction?
It was between the months that I owed rent up until that hearing.
Okay. And so then I guess I didn't follow what you're saying. You didn't pay rent when you left because there was still this rent reduction in place, or what was happening?
They didn't apply. They didn't change anything. It was similar to when I was paying when they didn't apply when they didn't make the corrections to my balance in August.
Okay.
And I was making payments. They didn't. They never applied those payments or anything to the ledger. And still remain the same from when the dispositionary was entered against me in June. That balance remained back in August.
Okay.
So back in January, when they did not make the corrections to my ledger, you know, I just had given up. I was living in an apartment infested by mold. I'm looking at the state of how my children felt living there, and I knew I needed to go. Like I didn't think that they were ever going to make the repairs. They were never going to agree or follow the order to apply the rent reduction. So I left. I left. I found a different apartment. I moved out.
Okay. So did you pay any rent in January?
No,
Did you pay any rent in February?
no.
Okay. And then in early March, you were gone.
Yep.
Okay. Did you let Grady know that you had moved out, or
I
you
didn't
just
know
let-
who to contact. As you can see, I've emailed several different people over time. I was never notified or given any emails of the email address in Bronner that's on every document, every correspondence, every court document. I would email and never get a response. So I honestly didn't know who to contact. I was at my wit's end and I left.
Okay. Did you pay rent in December?
No,
When was the last time you paid rent?
it was during that after that August agreement. They did not apply the rent reduction for September's rent. And they didn't make repairs to the mold. So that's what, through that time period, of, of, the hearing in January is when I was waiting for those discrepancies to be fixed
Okay. So,
before I made payments, because I had made payments in August and they filed a dispositionary against me. So if I'm constantly making my payments and adhering to my part of the agreement, the apartment complex continued to disregard the court order. So I was at my wit's end and I left.
okay. I follow all that. I understand that.
Sorry.
No, it's okay. And I know Mr. Douglas will explore some of this as well, but we can, need to re-explore what I'm doing. So was August rent the last rent that you paid?
Yes.
And did you pay in August the 1133 or the 1267 or some kind of number?
I paid what was agreed in the consent order.
Got it. So let me look at that again. That had you actually paying a whole lot in August because you were catching up, if you will. It was 2,000 plus 942 plus 942. You paid all those?
Yes.
Okay, so the last requirement, according to the consent agreement, was that you pay $942.69 by August 16th of last year, and you paid that.
Yes.
And since that point, for the reasons you've explained, you paid nothing.
Correct.
Okay, thank you. Mr. Douglas, I jumped ahead of you, but I just wanted to understand where we were. You said at the very beginning, actually, it's important that you hear all the numbers because my client's position is that there may be some money owed in the other direction.
Understood.
Okay.
And I intend to address that through my witness. I have nothing for Ms. Simmons.
Okay, all right. Ms. Simmons, I appreciate your testimony. I may think of something else that I ask you, so you don't need to stay up on the stand, but you'll be under oath if I do ask you something while you're sitting next to Ms. Shackelford, okay?
Yes.
All right, so if you brought anything up there, you should take it back with you. If that binder someone gave to you, you should leave the binder right there.
Okay.
Okay,
Thank you.
Ms. Shackelford, do you have any other witnesses to present? Okay, then I will turn to you, Mr. Douglas.
I'll call Brian Bowers to stand.
Come on up, please.
Raise me the red rider. Well, Margaret says more than the truth and all truth, nothing but just of God. And statements better than the
My name is Ryan Bowers, Ryan, Ryann, Bowers, Bowers.
And Ms. Bowers, tell us a little bit about your background, just for the benefit of the court and Judge
So I've
McBurney.
been in property management over 10 years, starting as a leasing agent and now in management.
And what is your exact title with Integral?
I'm an assistant community manager.
Okay. And above you, there's a community manager, is that correct?
Yes.
Okay. Explain for the court, we had some discussion earlier about Grady Multifamily as the actual entity name that is a party to this lawsuit. Can you explain the difference between Grady Multifamily and Ashley Auburn Point?
So Grady Multifamily owns Ashley Auburn Point. Some of the properties they have, they manage them, some they own. Ashley is one of those. Ashley Auburn Point is one of those.
And Integral, the company that owns the property manager that you work for, your employer, they are a partner in that Grady Multifamily entity, is that correct?
Yes,
And Integral is a partner in a number of entities like Grady Multifamily, is that correct?
correct.
And all of those entities own apartment complexes individually.
Yes.
How many apartment complexes does Integral own in Atlanta?
I would say over 30. I would say 30 to 50.
Okay. And does Integral also manage all of those properties as well?
Yes.
When did you begin working as the assistant community manager at Ashley Auburn Point?
November of 2025, 4, excuse me.
24. Okay. And what is your understanding of why you were brought in the first place?
So I was brought in due to the failure of the previous property managers. Once they were let go, I was brought in.
Had you been working at other Grady multifamily properties, or were you brought in from Post Apartments or some other place?
I was brought in, I wasn't working at another Integral property. I was brought in from outside.
And is it your understanding that what I'm going to call that Integral, what I'm going to call cleaned house, that the maintenance staff, the community manager, your position, the assistant community manager, all of those folks were replaced. Is that correct?
Correct.
And it was due to performance?
Correct.
When you began in late November 2024, was it brought to your attention Ms. Simmons's issues?
No.
Were you aware of a mold report that had been conducted at her apartment?
No.
You attended, though, the hearing as my witness in January that we've referred to several times this morning already. Is that right?
Yes.
And that's when you really became aware of everything that was going on. Is that?
That's correct.
And what steps did you take once you had a complete understanding of what was going on? Did you take any steps at that point?
Yes. So after the hearing, I made the property manager aware of what the concerns were for Ms. Simmons, and then he sought out the vendors to get the work completed.
And is it your understanding that the work was completed
Correct.
while Ms. Simmons was still living in the apartment?
Yes.
There were some photographs that were shown earlier. You saw those, is that right?
Yes.
Was that the condition of the apartment when Ms. Simmons left?
No.
Did you yourself take photographs of work as it was being done on the apartment?
Yes.
I'm going to hand you what I intend to mark as Defendant's Exhibit 1. Do you
Thank you.
recognize those photographs?
Yes.
Did you take those photographs?
Yes.
Are they accurate pictures of the conditions that you actually photographed?
Yes.
I'd like to, at this point, tender Defendant's Exhibit 1.
These were taken, I guess this would be in January of this year when the drywall guy was doing the things that Ms. Simmons described?
Yes.
Okay. Ms. Shackelford, any objection to Defense 1? It's 2 pictures, correct?
Yeah, just 2
Defense 1?
photographs.
Okay.
No objection.
Okay. Defense 1 is admitted. We're going to pause real quickly. Mr. Rao?
Yes, sir.
Can I help you with anything, or you're just spectating?
I thought there was a case on the calendar today.
There was one at 9 that Mr. Abate was supposed to be here for, a 4-defendant murder that has been specially set probably 5 times. And then at 1 o'clock, we have a bond hearing, but I think that's one below your pay grade. Those are the 2 things. You should talk to Mr. Abate about I think he calls it the Ryder case. Michael Ryder is one of the 4 defendants. Ms. Feely was here. She's the only lawyer of the 5 lawyers. Well, Ms. Cabrera snuck across. So 2 of the 5 lawyers. Regis radioed in, allegedly in trial in DeKalb. And then there's Ms. Bumpus. So
What's the date that it's specially set for?
the 14th of July.
Okay.
And we will be trying every defendant whose lawyer can be here. But Mr. Abate knows that. This was just could we please confirm that everyone's on the same page? And it wasn't a banner day for that. But he knows when it's happening, and I know he'll be there. I just wanted, this was a chance for people to say, oh, but the lead detective broke his arm again in this case. So 4 guys in jail since 2022.
Yes, sir. All right, well,
Thanks for dropping by.
take care.
You too. Thanks for your work last week.
Yes, sir. Thank you.
Sorry about that.
It's okay.
4 guys, 2022. All right.
So, Ms. Bowers, again, once you and your team became aware of the issues, you jumped quickly to address them. Is that correct?
Correct.
And they were in fact addressed
Correct.
before Ms. Simmons left the property.
Correct.
And was there any reason that you wouldn't have done that?
No.
Is there any reason that Integral as a company would not have, would have willfully just neglected repairing the apartment?
No.
So then why did it stay that way for so long? Because those pictures, I'm not putting this on you, but you're saying Integral's wonderful. They would never have done this. And Ms. Simmons clearly lived in that apartment with those situations for a while. And we can argue whether it was 2 years or 2 months, but it should be like a day the moment something like that gets noticed. And you weren't there to make sure it happened, but what Integral suddenly is on the ball, it wasn't on the ball before.
So I definitely can't speak to prior management, but once I was made aware, we quickly made the necessary steps in order for it to be taken care of.
Any idea, I mean, if you're speculating, don't answer, why it took Integral so long to get you and the new community property manager in, or community management person in place?
Yes, I can't speak to that.
Okay.
But it is your understanding that you were a part of the team that was brought in because of the performance of the prior team.
Correct.
Yeah. Let's talk generally about Integral for a second. out of you said there were approximately 35 apartment complexes.
Yes.
On average, how many tenants are there in each one of those apartment complexes?
And each one, on average, I would say between 100 to 300 tenants
At Ashley Auburn Point, how many units are there?
combined from phase 1 and 2. It is 354.
354?
Yes,
Okay,
That's units, not people.
units.
Okay.
right. And so there's some units that have 3, 4
Yeah, there's different
kids and,
household composition sizes.
right.
Yes.
So there could potentially be 1,000 people living at this apartment complex.
Correct.
Describe the layout of the apartment complex for the court. What generally, are there multiple buildings, physical buildings?
Yes, so there's multiple buildings. They consist of buildings 1 through 10. But the community is split up in 2 phases. And the phases are I would say phase 2 is all the units from 6,000 to 10. And then phase 1 is 1 through 4, buildings 1 through 4.
So there are about 5 buildings in each phase.
Yes,
So it looked like, just from the video, that Ms. Simmons lived in the 10 building. Is that correct?
correct.
Okay. She mentioned something about, I'm gonna remember it correctly, tax abatement, or it almost sounded like,
That's where I'm addressing next.
okay, it's almost like 2 neighborhoods. There's those are the tax reduction buildings and life is bad over there. They don't have electricity or running water. And then there's the side with the golf course.
That's exactly what I plan to address. Is there any truth to that?
So no, Ashley Auburn Point is a mixed community, but all of the units are mixed. So you wouldn't be able to tell who's in a tax credit, who's in affordable, who's in a market. Your neighbor could be market, it could be an affordable, but they're not split.
They actually integrate people into each building.
Correct.
There's not a building that's just tax credit or just affordable.
Correct. So no one would know if you were on a different program type or if you're a market.
You didn't make them wear little patches like
No,
I'm a
sir.
tax credit person.
No, sir.
And therefore, there aren't certain buildings that have more tax credit tenants than others.
No.
Is there any reason why Integral would neglect certain areas of the property?
No.
Are tenants allowed to have pets?
Yes.
Do these pets sometimes make a mess on the grounds?
Yes.
Do they make a mess in the halls?
Yes.
Do the owners of these pets, the tenants, do they always clean up behind their pets?
No.
Do they always clean up behind themselves?
No.
Is that just in your 20 years of experience in apartment property management, is that an issue that only Integral has to, or only Ashley Auburn Point has to deal with?
No.
Are there issues with the garbage overflow since you've been a community manager?
No.
Do you have an understanding of the number of, now that you've been there for 6, 7 months now, right?
Yes.
Do you have an understanding of the number of complaints of mold at the apartment complex, of all the units?
Since I've been there, no.
No, meaning you don't know, or there have been no complaints?
There's been no complaint since I've been there.
So you would know, as the assistant property manager, you would know if there were complaints of mold by any tenant in the apartment complex.
Yes.
And to your knowledge, is this the only mold-related complaint and issue at Ashley Auburn Point?
Yes.
And now it's been addressed.
Yes.
Is someone in unit 10205 now? Whatever unit Ms. Simmons had been in.
No.
Why is that?
They're in process of leasing that unit currently.
What's the occupancy rate of the community overall?
97%, I believe.
So why wouldn't, I mean, we're in almost July now and she left in March. Why would it not?
I think I was going to address that too next.
Okay, I keep stealing your thunder. You take it.
Yeah, that's okay. When did Ashley Auburn Point become aware that Ms. Simmons had vacated the unit?
I would say we're in July now. I mean,
Almost.
excuse me, June.
12 hours.
It was not that long ago.
Like yesterday or April?
I believe it was. I wouldn't say April. May. I want to say in May, late May.
So about a month ago?
Yes.
Okay. And are there things that have to happen once you understand that a tenant is vacated? Is there stuff that has to happen first before you can just turn it around and release it to someone else?
Yes.
And is that the stuff that's been happening?
Yes.
But the
Currently.
intention is to release that apartment unit
Correct.
soon.
Soon.
You saw the videos that were played about like the conditions of the grounds and the hallways and so on. Are those videos representative of everyday conditions at the apartment complex?
No.
You know, I'm gonna follow up with that. That's not what we would see today. Clearly, it's what it didn't look like some AI doctored video. It's how it looked when Ms. Simmons took those videos. Was that more representative of these types of issues that prompt an integral to say, not just management is gone, but maintenance is gone, groundkeepers are gone, et cetera?
Okay. Can you repeat the question?
Yeah, the videos we saw were not on your watch.
Correct.
That was before you and everyone else got there. But that's how it looked on that given day. And your testimony just now was, it doesn't look like that anymore. But we've got this whole new team in place. Do you have a way of knowing if that was just a particularly bad day for Auburn, Ashley, or that could have been how it looked before the new team was in place?
So I would say that it could be that particular day, only because there are times where if say our grounds haven't covered the area in which she's taken the pictures at that time, it could have been corrected after. So I can say that for the picture, also for the pictures that with the trash overflown, over the trash overage, that could have been a time where waiting for the trash company to come pick up the garbage is different variables to it, but I would assume that because of the change was needed, I was brought in.
Okay.
When you've got 1,000 people living in an apartment complex, there's gonna be stuff, right?
Yes.
Trash overflowing, poop in the hallway, dog poop, a dead rat
Yes.
in the parking lot.
Yes.
I mean, is that again, is that just an Ashley Auburn Point issue? Or again, in your 20 years of experience in property management, do all apartment complexes run across these issues?
Those are common issues for the apartment community to
Okay.
have.
In your role as the assistant community manager, are you the custodian of records for the apartment complex?
Yes.
So does that mean that you are familiar with the lease that Ms. Simmons would have signed?
Yes.
Does it mean that you are familiar with and you maintain the ledger that documents rent owed by tenants generally?
Yes.
Are you familiar with the ledger for Ms. Simmons and her apartment unit 10205.
Yes.
Well, you're marking that. Mr. Bate, good morning. Missed you this morning.
I apologize.
Change it to 2.
Hand up and Judge Williams with the presiding calendar. They're no longer just on Tuesdays, I guess.
No, they are correct. I'm happy to talk to your team about that, not during this bench trial, but they're now, judges can schedule them when they schedule them. Yeah. Ms. Feely showed up ready to go on rider. No surprise there. Ms. Cabrera came across. She's very, very anxious to talk to you about Mr. Lemons, and we'll take a break from there because she's co-counsel whenever you and she can talk about Lemons. Not clear when that trial will end. We start on the 14th. And the purpose of this morning was to really just get the lawyers together, although we brought the defendants over as well, to say, no, it's going to happen on the 14th. Regis says he's in trial in DeKalb. Ms. Cabrera did come over here. Ms. Feely was here, and Ms. Bumpus radioed something in about 2 hours late, but says she knows she needs to be here on the 10th when we call the calendar. So as long as you're ready to roll, it'll be what we start with on the 14th. Okay?
Yes.
Great. Thank you.
I hope we work out something there. We can do this week.
You could come in this afternoon, whenever works for your schedule and whatever lawyer or lawyers that might be. You don't. There's a bond hearing at 1, but it's not you. All right.
Thank you.
Yep. Back to this.
Is this an accurate copy of the
This would be Defense Exhibit 2.
Ms. Bowers, is this an accurate copy of the ledger for Ms. Simmons and apartment unit 10205?
Yes.
What's it dated?
It's dated for June 24th, 2025.
Okay, and did you provide me with this document?
I did.
And it accurately, if you had a chance to review it, is it the document that you provided me and it accurately reflects all the transactions that took place in connection with unit 10205?
Yes.
I'm wanting to enter Defendant's Exhibit 2 at this time.
All right. Ms. Shackelford, any objection to Defense 2?
Yes. This is the first time I'm seeing this document. It's 18 pages, front and back. So I or my client have.
Meaning it's 36 pages or?
That's my understanding. So I have not had the chance to review all of these entries or, the charges on here, the payments, the balances, the dates of them. So I'm not familiar with this. It was just handed to me today for the first time.
So what I'll do is admit it, so that we can have an initial discussion about it. And then I will certainly give you time after we stop today to look it over and if we need to reconvene, because you want to be able to ask Ms. Bowers questions about it that you're more prepared to ask. I don't mean that in a critical way. We can do that. Or you may just, after you've had a chance to review it, want to call your client back. So we can leave that open. But it does sound like this is although you're not challenging it this way, this is a record regularly kept in the course of business for Grady Multifamily. Probably something you should have received earlier. Hopefully some of the numbers aren't all that foreign to your client, especially if it represents the history of her time there. Then if it really is 36 pages, my guess is the first 34 pages are a history of paid. It just shows that she, meaning Ms. Simmons, regularly paid her rent, and then things got spicy in 24. So I'll admit it, subject to you being able to reopen, if you will, if you need to explore either through your client or through Ms. Bowers.
And it's probably also important to note that this same document was admitted in the January hearing. And this covers
Updated
the
from
4
January.
months from January through May.
Okay, important to note because that would have been a record that Ms. Shackelford's predecessor then at least would have laid eyes on.
That's correct.
Thank you.
I don't want to spend a lot of time on this. I think I just want to touch on what's most important for the court to note. Did Ms. Simmons pay rent in September of 2024, according to this ledger?
So we're on page 16 of 18.
No,
Did she pay rent in October,
no,
November,
no,
December,
no,
January,
no,
February,
no,
March,
no,
April,
no,
May?
no.
You attended the hearing in January with me, and the order from the court that was appealed is a part of the record already. There was an amount that the court ordered Ms. Simmons to pay. Do you recall that?
I believe it was around 7,000.
Well, whatever the amount was, it wasn't 7,000, but whatever the amount was, would this ledger reflect if she paid it?
Correct, yes, it would have.
Does the ledger reflect that she paid the amount that the court ordered her to pay?
Let's,
And for what month was that?
yeah, let's get everything. I'm going to share the order so we're all talking about the same thing. And then assuming you're talking about plaintiff's.
Does the ledger reflect that she paid the amount that the court ordered her to pay?
Let's.
And for what month was?
I'm going to stop sharing. When I share, weird things happen with the audio. So
Okay.
if you've got a copy of plaintiff's
This is
21,
the-
your version, oh, that's a different order.
Yeah, this is the order in judgment that was actually appealed.
Okay.
This order in judgment, or the consent order,
Yeah.
was from July of 2024. This is from the January hearing by
Okay.
Judge Drake.
Got it.
That is the basis for the appeal in the first place.
Okay.
Yes.
So do we have, I probably have a copy of that somewhere. And is that the 25 ED 333978?
That's the one.
All right. There was a voluntary dismiss order and judgment dated January 16th.
That's correct.
Says that okay, so it was a ruling in your client's favor for $2,707.
And 47 cents.
Yeah, okay, we're looking at the same thing.
Yes.
I can't share it because then audio will get weird, but.
But you recall that order.
Correct,
You've seen it.
yes,
The amount that the court ordered, was it paid?
no,
Okay. You mentioned earlier in your testimony that you learned of Ms. Simmons vacating the premises around the end of May.
I believe so.
And there are ledger entries on 527 that show a number of write-offs.
Correct,
Does that coincide with when you would have learned that May 27th date? Would that coincide with the date that you learned
yes,
of her vacating? Okay.
yes.
Prior to those write-offs, and we'll talk about the write-offs in a minute, but prior to the write-offs, what was the balance owed? What was Ms. Simmons responsible for on the date that you learned that she vacated the unit?
$10,390.79.
$10,390.79.
Correct.
Why would that have gone down? It was higher at one point, and there's some credits in April. Why would you be applying credits if she was gone. Do you see what I'm talking about? If you look at page 17 of the exhibit, go up towards the top on April 1st, sounds like you guys absorbed her security deposit. That tells me you think she's gone, not you personally, but someone thinks she must be gone. We're going to take her security deposit and credit that. So that would mean on April 1, somehow the system knew that Ms. Simmons was gone, which is almost 2 months before you might have, but you aren't the whole process. You're just one person. There was a question in there, and is why would on April 1 of 2025 there be a $350 credit for Ms. Simmons related to her security deposit?
I'm happy to ask.
I just asked. You don't need to ask anything yet.
So when write-off charges are, when we're moving someone out of the system, we'll write off all of the debt in which including the security deposit, which wouldn't be refunded.
Right. No, it shouldn't go back to her if you're owed all this money. But on April 1, someone credited the account with the deposit, which says to me, hey, she put the security deposit down. She's forfeited it now. We're going to take it and we'll use that to offset some of her arrearage. But you wouldn't do that, I'm assuming, until someone had moved out. And we're not going to give you your security deposit back, but we are going to use that to offset your debt.
So with her moving out at that point, because of the things that were left in the apartment home and some other things, the security deposit wouldn't be refunded. I don't know if I'm answering.
I'm not asking it well. I'm not challenging the decision not to refund the security deposit. I think that makes sense. Given how this played out, I think that it should not have been refunded. But it was credited to her account on April 1, not on May 27th. I'm asking, why would that have happened? Why on April 1 would someone have said, you know what, let's credit, she owes us a bunch, let's credit it now?
I can't speak to the why.
Okay. And there's an entry, another question, towards the end of April that says final resident utility, this and that. Why would those April 25th entries say final if you didn't know that Ms. Simmons had vacated until the end of May?
So the final water, which is a third party company that does the water and sewers. So if nothing was no usage was being used from the apartment, they'll send a final bill.
Okay. All right, back to you, Mr. Douglas.
There are two issues that I want to get to clarify. The first one is this issue of the rent reduction that was brought out in Ms. Simmons's testimony. On or during the period of July and August, or June, July, and August, there was an increase in Ms. Simmons's rent. Are you familiar with that issue? Why was that? Why did her rent increase from $1,300 to or $1,100 to $1,267? So
We have two different programs that require residents to do recertifications, which is also like a renewal. With the program rules, if you don't recertify, your rent will be pushed to market rent. And that's for two different programs, including the tax credit program, which Ms. Simmons was on.
Okay. And so the requirement to recertify is that a requirement of Ashley Auburn Point, or is that a requirement of the tenant?
It's a requirement of the tenant and it's a requirement of the program.
Okay. And if the tenant doesn't complete his or her portion of that recertification, what happens?
Then your rent is pushed to max rent, the max amount that you could pay under the program type.
And the max amount is market rate? That's what anybody walking in off the street would pay as rent?
Market rate for the tax credits. There's a max and that was what was charged.
Yeah, because it didn't go up all that much. It did go up and every penny counts, but
Correct.
it's not like it went from 1,100 to 3,000. 1133 to like 1267.
Correct.
That was just the difference between the rate that Ms. Simmons could get by certifying and then the tax credit level.
Max. So it wouldn't go over what she was charged of the 1267.
Okay. Market rate might be higher still, but she was within that tax credit group.
Yes, market rate is much higher.
Okay.
Okay, thank you for clarifying that, because I did actually think that the 1267 was market rate. So that's not market rate.
Correct.
Market rate's even higher than that.
Correct.
Okay. And so I know you weren't there in July 2024, but based on the ledger, based on the increase from 1133 to 1267, what is that an indication of?
Not completing the recertification.
So, and that again was the tenant's obligation.
Correct.
Okay. Would Ashley Auburn Point or Integral have agreed to reduce that amount back to 1133 on an ongoing basis for Ms. Simmons if she hadn't completed all of her requirements as a part of recertification?
If she would have completed her recertification, would she have been able to stay at that rental rate?
But if she didn't do what was required,
Right.
would there have been an agreement by Ashley Auburn Point or Integral to reduce it anyway?
No.
No. And based on your role as the assistant community manager, the 1267 amount that's reflected on the ledger was accurate. Is that right?
Correct.
Now let's address the write-offs that took place after or on around 5/27. That balance went from 10,390.79, which you indicated was the ending balance, to zero. Can you explain for the court why that happened?
So anytime there's a debt left, the company absorbs it and a write-off charge.
And is that so that the next tenant that moves into 10205, that they start with a zero balance as
Correct.
opposed to picking up the last tenant's obligations?
Correct.
Nothing further, Your Honor.
All right. Ms. Shackelford, do you have questions for Ms. Bowers?
I do, Your Honor.
Afternoon.
Good afternoon.
We're almost there. It's not quite afternoon.
So I think it was Defendant's Exhibit 1. Those were the two images that you took. I'm looking at these two images right here. Those were January of 2025, correct?
Yes.
Were these the only repairs done in the apartment complex, or excuse me, in the apartment?
Here in the closet.
So do you have other images?
I do not.
Okay. No, I understand that you were brought in.
I'm sorry, I gotta interrupt. When you say the closet, meaning the HVAC closet.
The HVAC closet.
Right, so the repairs are what we see here, which is to the entranceway. And then your testimony is, just no photos of it, is that was also some drywall work done inside the HVAC closet, which is basically that slatted door
To the right of
in the shade there. Okay, or the shadow. Okay.
So I understand that you were brought in after the hearing. And you've said that the repairs to Miss Simmons' apartment is something that I believe is still ongoing, correct?
No,
That the repairs weren't being made until after she moved out.
the repairs were completed while she was still residing in the home.
Okay, I apologize. I thought that you said that there was repair that needed to be done in the apartment after Miss Simmons moved out.
What I was referring to was like getting the carpet clean for the new resident to come in, but nothing that had to do with Mrs. Simmons' repairs.
So you're saying that the repairs to Mrs. Simmons, like the what we were referring to as mold, was repaired
Yes,
prior to March of 2025?
yes.
Do you have pictures of that?
These are the pictures.
These two pictures are the pictures of the repair that was done?
Yes,
Okay.
Plus some work inside the HVAC closet.
yes.
Sounds like, okay.
Do you have any updated pictures of Miss Simmons' closet?
Don't with me.
Okay. When were the repairs done to her closet then?
To her closet.
Mhm.
So I'm only aware of the photos here in the entry and in the closet of the HVAC unit.
Which I
Okay.
believe this is already asked and answered. We've already covered the period that the repairs took place.
Well, I think she's just clarifying, but I'm happy to short circuit it. You're only aware of repairs being done here in the entryway and the HVAC closet.
Correct.
Nowhere else in the apartment, not the daughter's closet, not Ms. Simmons's, the master bedroom closet, nothing done there.
Correct.
Okay. Thank you. Now, I believe you also testified that, and I'll just refer to them as Grady owns a lot of properties, correct?
Yes.
In your experience, are the type of conditions that we showed earlier, the videos and the dead rats and the maggots, is that acceptable for Grady? Does Grady find that to be an acceptable upkeep of its property?
I don't feel that those times were acceptable for any community, but those have been addressed.
So the fact that Grady has so many properties and so many tenants, that's not an excuse for not keeping the property in a sanitary conditions, is it?
Can you repeat the question?
Sure. Let me rephrase. Grady has a responsibility to its tenants to keep the property in a sanitary condition, does it not?
It does.
And you would agree that the video of the dead rat you saw, you would agree that's unsanitary, correct?
I would agree.
You would agree that the maggots that were by the dumpster were also unsanitary, correct?
Agree.
You would agree that the overflow of trash was also unsanitary, correct?
Okay.
My question is, you would agree that Grady finds that this type of property upkeep is unacceptable, correct?
I don't believe that Grady finds that to be unacceptable.
I think you're agreeing with each other.
Yes.
Okay.
And in fact, even though Grady has a lot of tenants, Grady wants to keep its standard of living, its property, the premises inside and out in sanitary conditions.
Correct.
But you don't know until you came in how often Grady kept unsanitary conditions, correct?
When you're saying unsanitary conditions, you're referring to the garbage and.
The feces and
So prior to me being there, no, I would not have known. But I would not have known that prior to me being there.
okay. And you're not aware of any prior mold issues just because it just hasn't been brought to your attention, or would you know of past mold issues?
So I wouldn't have known anything prior to me coming in, because the people that I would have spoken to weren't there.
So you don't know if there was other tenants who were experiencing mold issues prior to you working at Ashburn?
Prior to me working at Ashley, no.
Okay. I do want to talk a little bit about this ledger that you said that you've made, or correction, that Grady has kept. So, I'm looking at what's marked as it's page 15 of 18. So let's start there. I see that Miss Simmons' rent, as early as in August was at $1,267, and that she paid on August 2nd payments that equivalated $2,000. You'd agree with that, right?
Yes.
And then I see on the next page, which is page 16, that she made 3 other additional payments, which were in the total amount of $942.69, correct? And that was on August 13th, 2024.
Yes.
And then on August 16th, 2024, she made 2 other payments of $942.69, correct?
Yes.
So in August, Miss Simmons paid $3,885.38, correct?
If that's what those add up to, which
Yes.
is the amount she was obligated to pay pursuant to the consent order.
Right. So, because I believe that there was testimony that she had not paid those fees. So I just wanted to make the record clear that Miss Simmons did in fact pay those.
I see them.
Now I want to go to we're on the same page looking at September 1, 2024 rent. And that rent is listed at $1,267. Do you see that?
You said September 1 of,
2024.
and her rent charge was what again? I'm sorry.
$1,267.
Yes.
Isn't it true that there was supposed to be a write-off of $550?
According to the consent agreement.
Mm-hmm. So if her rent was supposed to be $717, I don't see that reflected on here, is it?
You said $1,217.
700,
The
717.
math would be 717 is what rent would be if it was decreased by the amount that the consent agreement indicated it would be. And so I think both Ms. Shackelford and I are looking for whether there is a secret entry in here that shows, yeah, actually we did reduce it. You can't tell by looking at this.
I don't see a concession.
So then I see throughout this that there were late charges, and I believe that there's a late charge of 10% that you guys are putting on her ledger. But then you go to page 17. And so I see a series of write-off charges. And so according to your own ledger, as of May 27th, 2025, on the last page, Ms. Simmons actually owes you $0. The very back of this document. It is the very last line of May 27th, 2025.
So the zero balance is because the company wrote off all of the charges, so there wouldn't be anything left.
Correct. So she actually doesn't owe you any money from your own ledger.
Well, we've already talked about this, that this witness testified that this is going to be my terminology, not an accountant.
Okay.
They clear the ledger so that the next occupant of 10205, because this ledger is linked to a unit, not a person, doesn't adopt the, hey, moving in, and by the way, you owe $10,390.
Yeah.
That would be a pretty bum deal to start out with. But I guess we should clear up. your client's not walking away from the $10,390 debt that you contend, I don't know if the math is right, but that you contend, or that Grady Multifamily contends Ms. Simmons owes.
Right, that's because it's attached to a unit, not a person.
Nothing further.
Mr. Douglas, any redirect?
No redirect, Judge, just would like an opportunity to give a brief closing.
Okay. Do you have any other witnesses? All right. Thank you for being up on the witness stand. You should leave there anything that was handed to you. If you brought anything up, take it with you. Any rebuttal evidence?
No rebuttal evidence.
Okay. I'm happy to hear from both of you now. You did point out fairly so that the ledger was new to you. Mr. Douglas pointed out also fairly so that it's not new to the litigation. It's something that your predecessor had. You did seem to be able to slice it up pretty nicely based on your questions. Are you comfortable, Ms. Shackelford, giving your final thoughts and words now, or do you want to do that at some other time after you've been able to better digest defense 2?
No, Your Honor, I think that I've been able to review it and pull from there what I think I would pull.
Okay. It turned out sort of what we expected, which is the first 13, 14 pages just showed a healthy history of she lived there, she paid, and we move forward. So, okay. Why don't you get us started then, Ms. Shackelford, if you've got things you want to summarize for me? Happy to hear them.
Your Honor, we're happy to waive and then say for.
Just like that. All right, Mr. Douglas, you're up.
So I'll just point out that the petition for review lays out very clearly 5 claims for damages owed to Ms. Simmons. The first one is that there was a refusal to comply with the consent order issued in case number 24ED312311. The second claim is that there was willful, wanton, and malicious retaliation against Ms. Simmons. The third claim is that Grady Multifamily is liable for punitive damages because they acted with willful misconduct, malice, fraud, wantonness, or oppression. The fourth claim is that Grady Multifamily violated the Georgia Fair Business Practices Act. And the fifth claim was for attorney's fees. I won't address them one by one. I'll just sort of hit highlights. I don't believe, just overall though, that there was any evidence presented to the court to support monetary damages at all, first. And in fact, there was testimony by Ms. Simmons that she mitigated her own damages by moving her personal belongings out of the space that could have been damaged. I guess if in fact there was mold, and if in fact those items had remained in that space, that they could have been damaged. But Ms. Simmons testified and even showed pictures that showed it sort of clear that she mitigated her own damages. I'll point out further that there is a requirement pursuant to an FBPA claim that there's a specific written notice that has to be sent 30 days prior to initiating action. And that requirement is not only laid out in the statute, but set out in Steed versus Federal National Mortgage Corporation. That citation is 301 Georgia App 801. It's a 2009 case. That again requires this specific, very specific demand letter as a condition precedent to an FBPA claim under 101399. And there was no evidence presented to the court that that prerequisite was met. And therefore, there is no valid Fair Business Practice Act claim. The court can't rule on that Fair Business Practice Act claim. Again, as has already been discussed at length, there was no reason to willfully or maliciously ignore Ms. Simmons and her concerns. There were some poorly performing management folks in charge, unfortunately, during the time that Ms. Simmons was a tenant. And once it was recognized by the powers that be, the folks who could make those decisions, they, again, cleaned house. And as further evidence that there wasn't a willful or malicious intent, once Ms. Bowers became a part of the management team, she in fact did something about it. But again, more importantly, Ms. Simmons hasn't demonstrated to the court that she was harmed in any way, that there were any damages associated with those conditions. I often get calls from potential clients that want to sue a restaurant that they ate at or a hotel that they stayed at. And I have to have this conversation often where I explain that there are two components to a civil litigation case. There's liability and damages. Liability, damages. You got to have both. It's not one or the other. And the analogy that I give to clients to make that clear is that, let's say I'm at an intersection waiting for my light to turn green, and it does, turns green, and I start proceeding through that intersection, and there's a driver driving perpendicular on the road, perpendicular to me, but they're trying to make the yellow light, and then it turns red, and they're still trying to make it, and they proceed through the intersection after their light's red and my light's green. And I see that car coming and about to hit me, and so I swerve out of the way. And it doesn't hit me. And I explain to potential clients that in that circumstance, unfortunately, I can't sue for almost being killed. I hear that all the time, like he almost, but it was almost, there's no redress for what could have happened. And then I go on just to make the point, overly, emphasize the point that let's say that driver was drunk. Let's say he had just murdered his brother. Let's say and I could go on and on and on, and all that does is add, it makes him look really, really bad, but it doesn't give me damages somehow. I'm not owed $1, no matter how bad this guy was, and no matter if he in fact broke the law and ran the light. And that's exactly what we have here, unfortunately, for Ms. Simmons, that potentially Grady Multifamily and Ashley Auburn Point looks really bad for having her live in that condition for arguably 5 months. But she's not owed anything as a result of it because she has no actual damages. Thank you.
You're welcome. Ms. Shackelford, you've reserved, now it's your time.
Your Honor, this case started with opposing counsel mentioning that there was no willful conduct by Grady. However, case law does define that wanton conduct is described which is so reckless or so charged with indifference to the consequences that it is the equivalent in the spirit to the actual intent of the law. That is from Atlantic Star Foods versus Burnell, 368 Georgia Court of Appeals, 2023. That is also from OC.
I need the other end of the site. So
368 Georgia Court of Appeals, 79 at 84 through 85, 2023.
Thank you.
And then the code statute is OCGA 5112 5.1B. So here, it doesn't matter that Grady owns a ton of other properties or that they brought someone else in the 11th hour to make amends for everything that they had done. They had subjected Miss Simmons and her children to living in these deplorable, unsanitary conditions. And in fact, the fact that they have so many tenants should be a reason why they want to upkeep their property so they don't subject the rest of their tenants to this type of condition. The fact that they brought in someone else or brought in another management company after these issues doesn't automatically make these issues disappear. Grady had a responsibility. The management company was their agent, was their representative, and that duty still applied to them. They still had a duty to clean up the property, to get rid of the dead rats, to get rid of the maggots, to make sure that there wasn't garbage overflow. The fact that we now have testimony that, hey, we came in and we fixed this issue, that still doesn't excuse your reckless or indifferent conduct to it. We also heard that Ms. Simmons has had no damage. This is not true. One of the very first things that Ms. Simmons testified to was that she had to move out. She has tried to work with Grady. And you've seen the documentary evidence that she has tried to work with Grady to present them with many opportunities to fix these issues. And as a result, she's had to move out. You even heard her testify, well, I had to move my daughter's clothing and buy a clothing rack, but there was no other storage in the apartment for me to move my clothing or my belongings, where my apartment, or excuse me, my closet also had what we're calling as mold. Now, we keep calling it mold, but the consent agreement entered into by the parties clearly states that the parties agreed that there was water and mold damage. Clearly, Grady, at the time that they entered into this consent agreement, knew there was mold. So there's damage in the fact that Ms. Simmons has had to move out. She had to buy a storage rack. Her property has been damaged. There's been moving expenses and moving into a new apartment. I know that the court agrees that Ms. Simmons should not be paid back her security deposit. But even now, knowing that they are in court, Grady still hasn't acknowledged their accountability, not only for the mold, but we also see that they were still charging her an increase in rent in September. They were supposed to decrease her rent by $550, which they didn't do. And this is the same issue that we had in June, when they were increasing her rent when they were not supposed to. Ms. Simmons has never said, hey, I just don't want to pay you, or I can't pay you. It was, there's an issue with my Flex account, there's an issue with my rent. How do we fix it? And instead of fixing it, they ignored the problem, just like they ignored the rest of the problems going on in the apartment complex, the mold, and all of those unsanitary issues. So we are asking that Ms. Simmons be awarded damages, that the damages that she has had to suffer for the rent that she has paid, for being subjected to living in those conditions, some of those being punitive damages, to deter Grady from allowing their tenants to continue in living in these type of conditions. Punitive damages for the type of living conditions that Ms. Simmons and her children have had to live in. Thank you, Your Honor.
Thank you. So I will take this under advisement. If I have question about something, or I want one side's opinion on, hey, could you get me case law about X? The email will go to both sides. And it wouldn't really ever be, hey, one side, tell me about this. It would be both sides weigh in on this question or this issue. I don't think I will. You've made a record that I think allows me to enter an order, but I do appreciate everyone's time this morning and the work that's gone into this. Ms. Simmons, your new place, is it still in Atlanta?
Yes, but in a different school district than my daughter.
Okay. Is that an improvement of school districts or not an improvement?
She wanted to graduate with the kids that she's been
Where had she been going to high school?
in high.
Oh, and where is she now?
She's gonna go to Drew Charter,
Okay, that's not a bad school. It's just she doesn't know everyone there.
and she's not graduating with the
people, the teachers, the community that she grew up with.
Sure, sure. Is she a junior or a senior?
She's going into her junior year.
Okay, all right. Well, thank you, everyone, for your time, and I will get something out soon. Have a safe 4th of July. You may. Oh, yeah, get your, I have a 2, so you can have, I have both those, so I'll just give them to Miss. Yeah, I'll take your binder. Thank you. This.